Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondaq webinar in association with Gun Plus Partners, which focuses on legal impacts of digitalization in the workplace in Turkey. We are joined today by an excellent panel. Begüm Okumuş is a managing associate in Gun Plus Partners, and she's been with the firm since 2007. Her practice focuses on data protection and privacy, corporate and M&A, life sciences and competition law. Filiz Esin has been with the firm since 2006 and became a partner in 2020. Her practice is focused on business crime and anti-corruption, competition and corporate and M&A. And completing today's panel is Beril Sapan. Beril joined the firm in 2008 and is now a managing associate. Her practice focuses on dispute management, employment, business crime and anti-corruption. Before I hand over to the panel, here is how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end of today's presentation. I would now like to hand you over to our speakers to begin today's webinar. Thank you.
Thank you. Hello everyone and welcome to today's session. As Begüm partners, we are happy to co-host this webinar together with Mondaq. My name is Filiz Esin. Today we are presenting legal impacts of digitalization in the workplace in Turkey. As you know, especially during COVID-19 times, employee data privacy has become one of the most debated issues all around the world and in Turkey as well. So we had recent constitutional court decisions on this matter, and during the webinar we will discuss employee privacy as well as the borders or conditions of employers' authority to have access to employee data. We think that the issue has multidisciplinary aspects, including data privacy, employment law, and criminal law. So we will try to cover all these areas. And just a little housekeeping before we get started. Like Dan mentioned, if you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel. And we will have time for answering to these questions at the end. And now let's turn to our first speaker, Begüm, who will explain the situation from the data privacy perspective.
Hi there, thank you for joining us and for your attendance in advance. Today we'll be talking about privacy aspects of digitalization in the employment context. So I would like to start with providing you a little bit background on the data privacy law in Turkey for those of you who are not familiar with Turkish law. So data protection law came into force in April 2016 in Turkey. And before the enactment of the law, private life has been protected under the Constitution. However, now we have detailed terms as they are introduced under the data protection law. Further, breach of data privacy, for instance, unlawful transfer of personal data, is subject to criminal sanctions under the Turkish Criminal Code, and Filiz will provide us further details on the criminal liability aspects. Data protection law is prepared mainly taking into account the rules and principles of the EU Data Privacy Directive. However, as at the time of the enactment of the law, the GDPR was also on the agenda in the EU. Therefore, certain principles of the GDPR have been also taken into account as well by the lawmakers in Turkey. The Turkish data protection law does not provide specific rules on employment context. There are several circumstances, as we all know, where employee data can be processed, whether it be on the basis of the consent of the employee or whether the processing can be made for the purposes of the recruitment, for the performance of the contract, for the employers to fulfill their obligations, liabilities, and to comply with the legal rules, and for the purposes of using and exercising rights and benefits related to the employment or arising from the contract, and even for the purpose of termination of the employment. So under the GDPR, sensitive data is processed with certain conditions, but unlike the GDPR, in the Turkish data protection law, especially in terms of processing health data or sexual orientation data, processing is only possible based on obtaining an explicit consent from the employee. And in very limited cases where there is a process held by the doctors for treatment purposes, etc., data can be processed without a need of a consent. So, whereas sensitive data other than health data or sexual orientation can be processed only when it is required by law. So having these all in mind, following the consent mechanism is actually inevitable under the Turkish data protection law when we talk about health data. On the other hand, in terms of personal data, when we are not talking about sensitive data actually, like in the GDPR, processing is held lawful if it is required, for instance, to execute or fulfill a contract, or to comply with legal obligation, or if it is required by law, or even to protect the legitimate interests. So we have similar legal grounds as the GDPR has. So these may be applicable in terms of the employment context. In terms of consent mechanism, Turkish data protection law has the same principles of GDPR, where the consent must be freely given. And prior to giving the consent, the data subject must be very well informed about the data processing, and it must be distinguishable from the other matters. Further, it is the data controller's liability as well under Turkish law to demonstrate that data subject has given its consent. In the employment context, of course, it is not easy to determine whether the employee consent is valid. However, considering the strict wording of the law and conditions set forth under the law to process especially health data, we must say that in the Turkish practice, employers, the companies had the necessity to obtain explicit consent. So this is our practice in that respect is different from the EU perspective practice. Therefore, it is necessary to obtain the explicit consent, even if it is required by law, even if it is necessary for the employer to carry out its obligations, or even if it is necessary to protect public health. And the key obligation of the data controller is, of course, to inform data subjects. This is the key issue. Under the data protection law, like in the GDPR, controllers must inform data subjects, and they must be informed about data processing activities, to whom their data is being transferred, or about the purposes of data processing, etc. Therefore, to ensure compliance with data privacy laws in the workplace, employers must ensure that they have certain provisions under the employment agreement. But of course, having the provisions under the employment agreement is not adequate actually, because the privacy notice must be prepared separately, and employees must be informed in advance with a separate document. And last, relevant consents or required consents must be obtained if need be. And in a digitalized workplace, of course, boundaries between the professional life and the private life became seamless in some cases. And the most debated issues, we may say, with regard to the privacy in the employment context, relating to the processing of biometric data, and also in terms of monitoring. And I will mainly touch upon in-vehicle monitoring and also systematic or on-spot monitoring of corporate emails. With respect to processing biometric data, Turkish DPA issued a decision. Some of you may have already heard about this, which was about a gym actually. And in short, the Turkish DPA concluded that the processing biometric data of the gym members was not found lawful, even if the gym itself had taken explicit consent from the members and also provided the members with the option to enter into the gym with a pass card alternatively. So it was argued that the consent was valid and it was freely given by the gym members. The Turkish DPA, in fact, concluded that it was not proportionate. Concluded that the processing biometric data is not in line with the purpose, is not proportionate with the purpose, and in cases where there are less intrusive tools to reach the purpose, then the data controllers must opt for the less intrusive ways. So the said decision of the Turkish DPA has also its effects in the workplaces where companies using, for example, retina scan technologies for entrance to the viewing places. The decision was debated among scholars, but nowadays we can say that it became widely accepted in practice, and companies have begun amending their entrance procedures for the workplaces to a more traditional way, going back to the issuance of cards and keys for the employees, etc. But it must be kept in mind that the specific workplaces where security of the essence, they can still use biometric data processing tools. We believe that the decision of the DPA should not be interpreted as if processing biometric data is prohibited for all of the workplaces. We believe that it can still be processed and provided by obtaining explicit consent of the data subjects if there is a necessity to ensure high level of security. And the other issue that we can talk about is in-vehicle monitoring. It is also applicable in the workplaces, and if the vehicle is linked to a specific employee, then of course we'll be talking about personal data in that sense. And as said, there must be a necessity for the specific position of the employee where the employer is required to monitor the employee's location during the working hours, like to audit the activities or the time spent out of the office. However, again, such an application must be proportionate with the purpose. Further, if private use of the vehicle is also allowed, then employees' consent must be obtained, or in-vehicle monitoring hours must be restricted if it is possible. And the employee must be informed of in-vehicle monitoring system beforehand. So proportionality is always the key element to evaluate because we believe that the data controller will rely on the legitimate interest legal ground while processing such data. And drivers, marketing personnel who are in need of working away from the office and visit clients and customers can be subject to such data processing activity. It is advised to inform data subjects simply with a plain language, even in the vehicles, to have the best practice. So, including in-vehicle monitoring, any surveillance of an employee actually must be proportionate, necessary, and justified. And we should not forget, if there are less privacy intrusive ways to fulfill the same purpose of data processing, the employer must opt out for these tools. So the GIM decision, the decision of the DPA about the GIM explicitly showed us the proportionality evaluation of the DPA. And when we come to monitoring of corporate emails, we have a lot to say. Because monitoring corporate emails, whether it be on spot or systematic, is exposed to many risks from privacy law perspective. And there are some DPA decisions as well as court decisions in this respect, and Beril will explain detailed discussions made at the Constitutional Court level later. We all know that private lives of employees usually extend into the workplace, and the companies are required to collect the corporate records and also backup emails to ensure security of the system, or sometimes conduct an investigation if there is any allegation of corruption, etc. So we may conclude that monitoring is not prevented by the law, but it must be justified, it must be necessary and proportionate as always. The recent decision of the DPA actually is about a subject who claimed that the company had accessed his corporate email account without his consent and made it public. In the decision, it is said that the subject, in fact, was a shareholder and a manager in the company, and backups of the general email account, info email account, was monitored by the company to understand whether the data subject's acts are corruptive or not, as he was not attending to the General Assembly meetings or reporting any transaction to the company, etc. So the company had initiated a lawsuit before the commercial court due to his corruptive acts and inappropriate money transfers. It was also understood that the data subject had applied to the prosecution office, claiming that his personal data rights were breached. However, the prosecution office dismissed his claims based on the fact that data processing activities were not related to his private life. In fact, his emails do not constitute personal consent. This part I don't agree with the prosecution office. However, at the end, the prosecution office dismissed the case, saying that, initiating a legal case before the court will not constitute a crime. So the case was dismissed. In fact, the company applied to the court to protect its rights, because upon the auditing, upon the investigation, the company had reached adequate information about the corruptive acts. So in sum, the Turkish DPA decided that the data controller, the company in this case, has access to emails and process personal data to exercise its legal rights. So there is a legal ground to do that. Therefore, the processing was made lawfully. In short, this is also a good decision of the DPA, where we can easily say that corporate emails can be subject to monitoring as long as it is proportionate, it is necessary and lawful. Data privacy impact assessments is advised to be made, even if it is not clearly regulated under Turkish law. We think that it is implied by the decisions. Further, informing the employees is of the essence in data processing activities. And inserting privacy provisions in the employment agreement may work, but actually it is not adequate, and consents should not be obtained under the employment agreement. Therefore, we advise to prepare a separate privacy policy for the employment context and obtain the employee's consent separately. Although the validity can still be questioned because we are obtaining it from the employee under the employment relationship. However, we can say that we have not come up with any court precedents in this respect. Now, I think Beril can further dig into employee monitoring in light of the Supreme and Constitutional Court decisions.
Hello, everyone. Today, I will briefly explain the approach of the Supreme Court and the Constitutional Court in terms of monitoring email correspondence of the employees. Actually, before the enactment of the data protection law, Supreme Court accepted that the employers can monitor its employees' email correspondences as long as employees' computer equipment are used. In those decisions, Supreme Court was relying on the management right of the employee. Then in April 2016, just few days before the enactment of the Data Protection Act, Constitutional Court granted a decision for monitoring employees' corporate emails. In this decision, the employees were informed that their corporate email accounts cannot be used for private purposes. And also, they were also informed in the internal regulations that the employer has right to monitor those email correspondences as well. So actually, based on this information requirements, the Constitutional Court decided that there is no violation of privacy rights and privacy of communication, as the employer had already made notifications and warnings to the employees for the monitor of their email correspondences. Also, in this case, the Constitutional Court also mentioned that the employer examined the email correspondences with a limited scope and only used those correspondences in the court case pending between the parties. So we can say that even before the enactment of the data protection law, the Constitutional Court mentioned the importance of the informing obligation of the employees. After, in April again 2016, the data protection law has enacted, and in line with the Data Protection Act and the decision of the Constitutional Court, which are on the same date, in May 2019, the Supreme Court changed its precedent. The Supreme Court is still of the opinion that the employer, within its management right, can monitor its employees' electronic communications, provided that employer's equipment is used. However, in this case, in line with the Data Protection Act, Supreme Court also accept the information obligation and say that the employees should be reasonably informed by the employers about monitoring correspondence. Otherwise, they will not monitor their email correspondences. More importantly, at the beginning of last year and at the beginning of this year, the Constitutional Court granted two recent decisions on monitoring employees' corporate emails. The first decision of the Constitutional Court is dated October. In this decision, applicant was a lawyer who was working as an employee of a law firm. In this decision, the Constitutional Court decided that applicant's right of protection of personal data and privacy of communication has been violated by the law firm. To give you details, in this case, actually, several employees in the applicant employees team submitted complaints against the employees, such as she was being very rude to the other team members, she was not objective towards her team members, and according to the workplace, peace was breached. Following the complaints, the employer started to review the employees' corporate email accounts. And based on the correspondences they found in those corporate email accounts, the employee's employment was terminating based on a just cause. Both the first instance court, the first instance labor court, and the Supreme Court decided that the termination was based on a just cause. Then after, the employee applied to the Constitutional Court. In this application, the employee explained and claimed that the employer examined personal correspondences on the corporate email accounts without taking consent. Also, there are no rules at the workplace indicating that employees' emails can be reviewed. The employer conducted the inspection to look for a reason for terminating the employment. The employer reviewed thousands of correspondences, and among these, the employer relied on personal emails written in belief that the employer would never read. So she basically claimed that her right of protection of personal data and freedom of communication were violated. Upon this application, the Constitutional Court determined that the employer did not inform the employees that their email correspondence can be monitored and reviewed. Thus, the Constitutional Court stated in its decision that the employer failed to prove that it informed the employees as per the data privacy law rules. The decision further stated that the employer failed to explain whether there had been a necessity to access the employees' email communications. According to the decision of the Constitutional Court, the employer couldn't set forth the reasons for proceeding with email examination as essential and necessary. The court explained that there were other tools serving the same purpose, such as analyzing the parties' complaints and defenses, hearing witnesses, examining workplace records. So, as the law firm didn't conduct those activities, the Constitutional Court decided that the principle of proportionality has also breached by the employer. Also, in this decision, the employer examined the correspondence with the third parties, in addition to the correspondence between the team manager and the applicant employee. Also, the inspection was not limited to the allegations in questions. Therefore, the Constitutional Court decided that the employer accessed the email contents with an uncertain scope. Accordingly, the Constitutional Court ruled that the employer violated the right of protection of personal data and freedom of communication. In this respect, the Constitutional Court sent file to the First Instance Court for retrial and decided on moral compensation in favor of the applicant of the employee. So to sum up in this decision, actually Constitutional Court explains the basic principles such as principle of proportionality, principle of necessity, and principle of transparency. At the beginning of this year, in January, the Constitutional Court once again granted a decision for monitoring of corporate emails of the employees. In this decision, the Constitutional Court found that there had been no violation of the rights of the personal data protection and freedom of communication, as in the employment contract, it was explicitly stated that the employee could use the corporate email for only business purposes, and the employer could examine the email account without notice. Again, in this decision, the Constitutional Court gave importance to the informing obligation. To give you details about this case, in this case, the applicant was an employee of a private bank. There was an internal investigation as there is a complaint that the applicant also worked at a business registered in the name of his wife. Upon reviewing the emails by the bank inspector, the inspector prepared a report. And in this report, the inspector found out that the employee founded a company in the name of his wife. He sent various payment documents to the company's accountant through his corporate email. He even filed a loan application by conducting negotiations with other banks regarding the company through his corporate email. He also reviewed his wife's account on a frequent basis. Due to this reason, as the employee wasn't doing his duties during the work time, the bank terminated the employment based on valid reason. In this case, the employee first filed a reinstatement claim, but his claim is rejected by the First Instance Court, and the Regional Court of Appeal upheld the decision. So after those steps, employee applied to the Constitutional Court. The applicant's employee claimed that the employer had reviewed his correspondence in his corporate email account without prior notice or consent. His employment was terminated in an unlawful manner based on this correspondence. He also claimed that his work performance has always been very high. And finally, he claimed that his right to protection of personal data and freedom of communication had been violated. When we come to the reasoning of the Constitutional Court, Constitutional Court in this decision explain the main principles. The Constitutional Court explained the principles of necessity, principle of purpose specification, principle of transparency, principle of legitimacy, principle of proportionality. And after examining and explaining those principles, the Constitutional Court ruled that the employer reviewed the corporate email accounts to ensure that the employee has performed his duties. So in this decision, the Constitutional Court also accepted the management right of the employer. According to the decision of the Constitutional Court, as the employer is a bank and employs a large number of employees, there is a legitimate interest in terms of workplace management, and review of emails was an eligible method to achieve the desired purpose. The Constitutional Court further stated that in the employment contract, it was explicitly stipulated that the employee can use corporate emails for any business use. Also, the bank management could carry out an inspection at any time without any prior notification. Therefore, the Constitutional Court explicitly mentioned that the employer fulfilled the explicit information requirements, and the employee had consented to the inspection by signing the employment contract. Also, it was mentioned that the employer reviewed only the messaging supporting the claims regarding the email working at another job, and used such communication during the trial process to prove its arguments. In this regard, the Constitutional Court ruled that the employer had conducted an inspection limited to the purpose of processing and used the collected data in compliance with the purpose. The Constitutional Court found no violation of the applicant's rights to personal data protection and also the freedom of communication. Thus, this recent Constitutional Court decision once again draw the attention to the importance of the principle of transparency and also principle of proportionality. So I think now Filiz can explain the criminal aspects of the data protection.
Yes, thank you, Beril. In the last section, I would like to elaborate criminal aspects of data privacy, which we think is also important for litigation case or internal investigations within a company. Well, data protection law, as we mentioned in the beginning, entered in force back in 2016, but actually criminal sanctions on data protection breaches date back further than the data protection law. We had privacy violations regulated under criminal code since 2005, actually. When I say privacy violations, I mean privacy of communication, personal data, and privacy of life. So these are the areas that our criminal code has already covered. So there are many cases of Supreme Court about privacy matter. In addition to that, the Turkish constitution protects the right to personal data since 2010. So the data protection law introduced new rules and principles for processing personal data and referred to criminal liability in case of breach of the law. So it is important now for us to understand how these two laws will apply together. Maybe one additional note before moving on. Article 18 of Data Protection Law clearly identifies the types of breaches such as breach of disclosure, breach of data security, etc. And the law considers this kind of breaches as misdemeanors. And administrative sanctions rendered by the board are challenged before the criminal courts of peace. Whereas Article 17 of Data Protection Law makes a clear reference to criminal code in terms of crimes concerning personal data. So we have two types of sanctions at hand. I want to talk more about the crimes set forth under the criminal code. I will actually, there are more articles, but I will mainly touch on 3 articles that I would like you to remember during this session. Well, first article is Article 135. It's about illegal recording of personal data. and this article sets out a penalty of imprisonment from 1 to 3 years. Our second article is Article 136, and this article is about illegal transfer, dissemination, and obtaining personal data. And this article foresees an imprisonment from 2 to 4 years. And the last one that I want to mention is Article 138, and this article is about failure to destroy personal data. And the article says that the non-destruction of personal data, despite of the expiry of the retention period foreseen by the law, results in imprisonment from 1 to 2 years. So briefly, these are the three articles that we should remember, I guess, when we have a situation to consider at hand. Another important point is that there is no definition of personal data in criminal code. So the data protection law must help the courts to define and analyze the concept. I can say that the courts, the criminal courts and the public prosecutors are not very familiar with the new developments and with the new concept of personal data. So the law and the board with the authority with its decisions should help the guide also the court in that sense. Of course, when we talk about a crime, we must mention about the elements of the crime, and intention is certainly very important. The intention of the perpetrator should cover the illegality as well, say the scholars. What they mean here is that the actor of the crime, the offense, must knowingly and willfully, I mean deliberately and intentionally, act with the purpose of illegally transferring data. Now I will go back to the three articles that I mentioned. I checked the case law, the Supreme Court decisions when preparing this presentation, and I noticed that for illegal recording 135, there are around 60 cases, whereas for illegal transfer of the data, dissemination of the personal data, 136, there are more than 300 cases rendered so far by the Supreme Court. And for the failure to destroy personal data, there are more than 150 cases already rendered by the Supreme Court. Especially we must analyze, I guess, the Article 136 about illegal transmission, dissemination and obtaining personal data. The Supreme Court says that when we talk about transmission, we understand that there's a transfer to one person, whereas for the dissemination, there's a transfer to a group of people. So the court analyzes each section eventually. And among the decisions that we read and analyzed, we can categorize the decisions like that. The majority of the decisions are about dissemination of pictures, especially on social media such as Facebook, without the consent of the victim or data subject. The second category that I can mention was about obtaining details of credit card holders, for example, and another category that I can mention is about transferring the details of customers to third parties. Like you can see, there are no very complicated cases about relationship between employees and employers or monitoring emails during an internal investigation. I noticed that there are only 11 Supreme Court decisions which clearly refer to data protection law after 2016. And among these decisions, I noted that they're mainly about electronic evidence in an investigation about an organized crime when the police or the public prosecutor analyzed all the emails, including personal data of the suspects. So to sum up, we should say that there are no sophisticated cases in the Supreme Court so far which can guide us about the methodology and the way to handle the data protection law and the criminal code at the same time. But I guess it is very important to note that in Turkey we have personal liability in terms of criminal liability. So we don't have, unlike some other jurisdictions, we don't have corporate criminal liability. Corporations, like companies, can be subject to security measures. By security measures, I mean decisions of the courts about cancellation of business license of a company. But the managers, like real persons, will be held personally liable for a criminal offense. Therefore, the data processors within a company must be very careful from that perspective, I guess, since they can be personally liable for an illegal transfer of personal data to third parties from a criminal law perspective. Obtaining evidence, monitoring emails during an internal investigation, evidence gathering situations are really important to determine the strategy of a litigation. And so in that sense as well, companies must be very careful during monitoring of emails. These were the main points that I wanted to highlight during my session about criminal law. Begüm, why don't you go ahead with our closing remarks before moving to Q&A session?
Sure. As mentioned, Beril also mentioned and Filiz clearly explained, the DPA decisions, also the Constitutional Court decisions or the Supreme Court decisions, or even the prosecutors, actually, they all refer to main principles when evaluating a claim or a case. Saying that is data processing proportionate, is it necessary or justified? And actually we believe that these are all global rules and principles, so we are all speaking about the same language almost all over the world. So we must say that and admit that the local courts in Turkey and also the prosecution offices, they may not be very experienced on implementing the data protection law. Even the Constitutional Court, I mean, they might evaluate some aspects not very much in line with the data protection law itself. But the higher courts, they are generally in line with each other based on these global principles and rules, which are also protected by our laws and constitution and under the international agreements that we are party to. So based on these main principles, we are receiving parallel decisions from the constitution courts, etc. But I agree. I mean, actually, one of our participants has also noted that is it okay? Is it really okay to have certain provisions under the employment agreement and get the consents there? Apparently not. I mean, it should be, because implementation of the data protection law is important, and we don't nowadays expect the local courts to implement it correctly. They are not that much experienced, but I think they evaluate the cases on a higher level, as I said, from these, by taking into account these kind of principles. Of course, we advise that privacy policies, information obligation must be fulfilled under a separate document. It must not be inserted somewhere in the employment agreement, or the consent should not be obtained under the employment agreement. It must be taken separately. Privacy policies must be provided to the employees separately, that is for sure. And even in such a case, as I said, it can be still questionable. I mean, whether it is really valid or not. But for now, the court's evaluation is not that much sophisticated for now, but we don't know what will happen in the future. And what lessons we should take from this session actually, we can say that monitoring is not prohibited in principle, but of course must be limited, and certain rules must be followed. And privacy impact assessments, although not regulated under Turkish law, it is advised before implementing any monitoring activity, because as I said, the main principles are always in mind of the DPA, of the courts as well. And automated monitoring can be in place for specific matters, for instance, to ensure security. And monitoring of calls, it must be really restricted, only in cases when there is a real risk of criminal conviction or disclosure of a commercial secret. So in those specific cases, it can be the case. So we are talking about very rare situations in that sense. And monitoring must not be initiated by unauthorized persons. And these persons who are doing the monitoring, they must have certain level of data protection knowledge. They must have been trained so that the monitoring itself will not become an intrusive action. The company's rules and policies must be known by the employees. So I would like to again mention that it cannot be inserted somewhere in the employment agreement. There must be a separate and a plain document in that sense. Employees must be informed in advance. And in terms of sensitive data, this is the problematic issue in Turkey, and when we talk about health data, explicit consent is required. Although it may not be the intention of the employer to process that type of data, we all know that email correspondence may include sensitive data. For instance, the employee may be receiving health reports from the hospital, etc., and using his corporate email account. This can be the case. So employer must have obtained the explicit consent of the employee in advance. And the employer also must take into account the data minimization rule at all times. And in terms of informing employees, it is not that easy actually, and how detailed such information should be. In terms of investigations especially, it is sometimes difficult to provide the employees with detailed information if we are talking about a covert investigation, right? So the employees may not be informed or very well informed in advance. But what we can do in practice is to provide them with a general information about that the employer may conduct investigation, and their corporate emails can be audited, etc., so that the employee will know whether automatically or on spot basis an investigation can happen and emails can be audited. And ban on personal use of emails, honestly, we must say that it is not the key solution. I mean, if we ban personal use of emails, can we solve all the matters? In my opinion, no, it is not the sole solution. In fact, the practice of the company is also important. Even if it is banned, the company may allow such kind of usage, and the practice will override the provision of the employment agreement somehow. So, and also further, scholars think that it is not fair to ban personal use of emails, accounts, considering the long working hours. And even if it is banned, employee can still use it for personal purposes and will still benefit from the protection because it's a fundamental right. And illegal processing of personal data and relying on such data as a proof in case of a claim in litigation can badly affect your litigation strategy. So privacy rules must be taken into account at all times. And last, as Filiz said, illegal processing of personal data may entail criminal liability. Sometimes data subjects directly make a claim before the prosecution office, or sometimes the Turkish DPA also reports the cases, the claims to the prosecution office. So it might entail criminal liability that the company must be aware of. And I think that's all for now from our side. We thank you very much for your attendance and attention. And I think we can now check if there are any questions from the audience side.
Yes, we have a couple of questions. We can answer to those questions in a few minutes, I guess. You already answered to one of them, actually, Begüm, about clarification statement in the employment agreement. There's another question from data privacy perspective about international transfer of data, actually.
I can briefly respond, Filiz.
Yes,
it is about it is about the use of online tools. We all use all of them, most of them, for the business meetings. While working from home, we are always using the online platforms. These apps and softwares are foreign softwares for sure, and they have their servers abroad. So we have the transfer of data abroad issue. But all of the companies have the same problem, actually. As we don't have the safe country list at hand, we need to either rely on obtaining the explicit consent from the data subject, or to apply to the Turkish DPA with an undertaking and obtain a permit from them, which we all know that it is not that much easy and it takes time. So in practice, it is practical to obtain the consent from the employees, because I believe that here it is the employer who is acting as a data controller, because we are all using these platforms as part of our work, as part of our duty. And the employers are the data controllers here. Of course, these online platforms also have their own data processing purposes and activities. It is within their area, actually. They also should have certain privacy policies, and information must be provided to the users, etc. But from the company's perspective, I believe that informing the employees about usage of those platforms and informing them about that use of these platforms may entail transferring personal data abroad, and therefore the company must have their consent to be able to lawfully transfer data abroad. This would be the plausible option, in my opinion. This can be done in an employee privacy policy, or an annex, an additional document can be prepared in this respect. It depends on the company's strategy.
Yeah, maybe we can combine with this one, Begüm. Before an employee enters into the company computer, a pop-up appears warning them their emails can be monitored. Employees are also warned not to use company computer for personal purposes. Would this satisfy the employee consent? Our attendee says.
Actually, I don't define it as an employee consent. It is important to inform the employees about the monitoring, and I think it is one of the best ways to inform them, because it is important to inform them under the privacy policy, okay, but also more importantly, that information must be provided periodically, because the employee must not forget about it. So these kind of pop-ups are very good examples, actually, in that sense. But I don't think that we need to get the consent. As long as we act in line with the law in terms of monitoring, in terms of monitoring the corporate emails. As long as it is necessary, as long as it is proportionate and lawful, we don't need the consent. I mean, in these cases, even if we have the consent, these consents will be held invalid, actually. So for providing the information, I think, as I said, it is one of the best examples.
Mm-hmm. Beril, there are a couple of questions about employment contract and employment law. Maybe you noticed. One of our attendees says, is it mandatory to have a home office clause in the employment contract? And is it the employer obliged to pay a home office allowance, reimburse expenses linked to home office? Since this is our new workplace.
So, I mean, under normal circumstances, we have a specific article which regulates home workers in our Labor Act. And according to these articles, the employment agreement should be in writing. But most of our clients, and including us, we are working from home due to COVID situation. And the scholars accept that for limited scope of COVID situations, this is a health and security issue. So you can somehow let your employees to work in home office, and then you don't need to take the consent. But if you just, decided to work on a full-time basis from a home office, then you will need the consent of the employee because this will be a material change. But for the COVID situation, you don't need the consent. It is also discussed amongst the scholars whether the employer is obliged to pay a home office allowance or not. We have a provision under Code of Obligations, and we think it is also applicable for employees as well. So we suggest our clients to make a lump sum fee for their home office allowance, and several of our multinational clients have already done that. They drafted a policy for home workers, and they are usually prefer to make a lump sum payment. And I think there's another question about the signing of the contract. Yes. It depends on the type of the employment contract. I mean, under Turkish law, we don't need an employment contract in writing. There is no obligations, but there are some exceptions. For example, for home workers, the employment contract should be signed in writing. For example, fixed-term workers, again, the employment contract should be signed in writing. E-signature is not actually accepted as a qualified signature, so we would suggest taking the wet and original signature of the employees. The courts also seek for that.
Thank you.
I think we don't have further questions in terms of employment.
Yes, we don't have any other questions. We have only one question about data privacy, but I guess it was already handled about the consent of the employee.
About the data transfer abroad issue, but it is a problematic issue. I don't mean that obtaining the consent is the valid solution, because consent can be always withdrawn, or while using that tool cannot be withdrawn. So it is not the best approach, but taking into account of the wording of the law and the materials that we have at hand, as we know the practice of the DPA, as we know the fact that there is no safe country list, and as we also know that applying to the DPA and submit and undertake and then get the permit, these are not easy things. So I mean, the DPA recently issued a decision, and one of the data controllers has already obtained a permission for the data transfers. But this is just one case, and we don't know in how many applications they have issued this one. We all know that it is a hard process. So considering all this, I see that obtaining the explicit consent is the only option practical for now. I'm sorry to say that.
Thank you for concluding with that. I think we are on time. Thanks for everyone's attention and for questions and for participation. Have a good day.
Thank you all. I hope you enjoyed.